Okay, we're a couple of minutes past the hour. Let's get started on this webinar. Thank you for joining so much. My name is Kimball Parker. I'm the CEO of SixFifty, and we are partnering today with the Salt Lake Chamber of Commerce and the World Trade Center to talk to you about privacy law, and specifically this new Chinese privacy law that's emerged. So for those of you who are hearing about SixFifty for the first time, we are the technology subsidiary of the law firm Wilson Sonsini. And so it's not a stretch to say that Wilson Sonsini is one of the best law firms in the world. They founded Apple and brought them public, same with Google, same with Twitter, Lyft, SpaceX. The best, most exciting technology companies in the world use Wilson Sonsini, including a lot of big Utah companies, Pluralsight, Domo, Divvy, Podium, have all kind of run through Wilson Sonsini. So I want to back up. I just want to talk about the law more broadly to give you some context about what we do at SixFifty. So in order to comply with certain laws and privacy laws in particular, businesses need paperwork. They need policies and procedures and notices and contracts. And those documents need to say the right things. And if they don't, there are serious consequences. And that is especially the case with privacy law. So what lawyers do is they make the paperwork say all the right things. And so what we've done at SixFifty is we've worked with the law firm Wilson Sonsini to teach a computer to write legal documents that say the right things. So our products, one way to think about it is that our products are like TurboTax, but with the best lawyers in the world behind it. And the idea is to make top level legal expertise that can cost upwards of $1,400 per hour, to make that affordable and available to any company. So we like to view ourselves like Robinhood for the law. So anybody can enjoy the same kind of legal help as Google gets. So, okay, so today let's start to drill down. We're going to be talking about the emergence of privacy laws, and this has been in the past several years. There's been a movement around privacy in the law, and so 10 years ago, for example, when you created a Facebook account and uploaded all your information, Facebook owned that data. They could sell it, they could analyze it, they could delete it. If you wanted it back, tough luck. It's not your data anymore, it's Facebook's data. And Europe changed that paradigm. So in 2016, the EU passed a law, a new regulation called the GDPR. And that new law basically said, organizations don't own your data, you do. So if you want it back, if you want your data back, you can get it. If you want to know what they're doing with your data, you can do that too. It's your data. And these companies are essentially borrowing the data from you. It's like putting your money in a bank. You can take it out whenever you want. And that's roughly kind of how Europe started to structure the relationship between people and the data that they give to companies. That was a seismic shift in the law. And Europe gave companies 2 years to comply. So they passed that law in 2016, and the deadline to comply with the GDPR was in 2018. So other countries and states started to look at that law, the GDPR, and say, hey, we like that setup. So California passed a similar law in 2018 that went into effect on January 1st, 2020. Colorado and Virginia just passed similar laws that will go into effect in 2023. And other countries like Brazil have passed similar laws. And this leads us to China. So on August 20th of this past year, China passed a law similar to the GDPR. There's some differences, and we're going to get into that. But it's similar to the GDPR. It applies to any company that has employees in China, collects data from people in China, or does business in China generally. So it's the application of the law is broad, and we'll dive into that too. But instead of giving companies 2 years to comply, like basically every other law that had been passed, China is requiring companies to be compliant within 2 months. So companies have to comply by November 1st of this year. So very fast turnaround. And because it's China, the consequences are severe. So when we'll talk about this. This is a serious law with serious consequences. And there's a lot the companies have to do. So today, what we're going to do is we're going to compare the GDPR to China's new law, which is called the PIPL, the Personal Information Protection Law. So you're going to hear from two privacy experts today, and this is going to be some dense information. So just prepare yourself. The first is Marie Colbeth. Marie graduated near the top of her class from one of the best law schools in the nation. She clerked for a federal circuit judge in the South. And for those of you who are a little unfamiliar with the legal system, that's the court that's right below the US Supreme Court. She worked in private practice and then was a professor at BYU Law School. And we poached Marie from BYU. And it was one of the best decisions we've ever made. It's really is not an exaggeration to say that Marie is one of the top privacy experts in the nation. So prepare to be impressed by the dense privacy information she is about to feed you. So number two, you're going to hear from Austin Smith. Similar resume, graduated near the top of his class from one of the best law schools in the nation, the University of Virginia. He also clerked for a federal court judge. He worked in private practice for some of the biggest law firms in privacy, Hogan Lovells, Davis Wright Tremaine. And that's where we got Austin from. We poached him away. Again, one of the key moments, for our company. Austin, just like Marie, is one of the top privacy experts in the nation. Now, where Austin and Marie really stand out is their understanding of the new China privacy law. And the reason why that's the case is because since that law passed, we have been working nonstop with Wilson Sonsini and privacy experts in China to understand what companies need to do to comply. And today, literally today, this morning at 5 a.m., we launched an automated product like TurboTax to help companies create the policies and notices and contracts and impact assessments and all the compliance document they need. Basically, to automate all the things that a lawyer would create for you for this law. And so Marie and Austin are the two big brains behind that project. And so you're going to hear right from them. Okay, so just some housekeeping items. If you could put your questions into the Q&A, not into the chat, that would be very helpful. So please put the questions into the Q&A, not the chat. Second, we're seeing high demand for this China privacy compliance product. If you want to get on the schedule, we have made an arrangement with the chamber. We're going to prioritize chamber members. You can visit 650.com/China. And there you can sign up for a demo. Again, we launched the product today. So we're a little slammed right now, but we will prioritize chamber and World Trade Center members to show them the tool. Okay, so without any further ado, prepare yourselves for 50 minutes of mainlined privacy knowledge into your brain from Marie and Austin. Marie and Austin, take it away.
Thanks, Kimball. I will try to do my best to live up to that while also not boring people. But thank you so much. And thanks also to the Salt Lake Chamber and to World Trade Center Utah for putting this together so that we could make sure that our community of Utah organizations and companies are able to be aware of and understand and comply with the law. So we appreciate that. We are going to start off to give you a little bit of understanding of what we'll be talking about today by talking about the coverage of China's new law, the PIPL. So, territorially, what does it cover in terms of actual information, what information is covered, rights that are afforded to individuals in China under this new law. And so as companies operating in China, rights that will have to be respected, documentation that will be needed to comply with the PIPL, and then potential liability and enforcement actions that are authorized by the law. So that's sort of an overview of what we'll be going through today. We're going to dive right in and start talking about the scope of the law. with the PIPL, and also just by way of information on our slides today, most of the time you'll see either a visual of China or Europe, or both if we've divided them in half and are showing information about both jurisdictions. So that's just to help orient you on the slide deck, which we will share after the webinar. So with this law in China, you have really similar coverage rules as what you see in Europe with the GDPR if you're operating in the EU. And so essentially, if you're handling the personal information of any individuals inside of China's borders, then that data and that information is covered. So think, for example, if you're a multinational company, you have an office in Beijing, for example, the personal data that the Beijing office is collecting and processing is going to be covered by the law. However, if maybe you don't have an actual presence in China and you're handling the personal data of Chinese persons from outside of China, so maybe you have a website and somebody in China can get onto your website and input their information to become a lead or to purchase something from you or whatever it is, that is also covered, because even though you're handling the personal information outside of the borders of China, the purpose is to provide a good or service to somebody in China, or to analyze or assess the activities of persons in China. And that second example, analyze or assess, is something where you might think more along the lines of something like a social media website or some other site that's analyzing actions, even though it's not necessarily providing a physical good or some sort of direct service. So even if you're just analyzing the data so you can sort of make some determination about like, well, what might sell well in China, what might we want to market over there, even if you're not doing it yet, that also would still qualify because you're analyzing the PI to make determinations about people in China. And then we just have this really broad catch-all in China, which you see a lot in this law, which is other circumstances provided for in laws. So they're sort of leaving themselves an out to incorporate more. And that's something that we kind of see commonly here, where, they're sort of leaving themselves a lot of room to decide that something is covered by the law if they want it to be. And that's, I think, really different from what we see in Europe, where they have the similar idea where if you're processing the data of people in Europe, whether you're in Europe or outside of it, if you're, offering them a good or service and you're outside of Europe, it's still covered. But Europe doesn't have that sort of generic catch-all that China has. And so when we talk about personal data, so when we know where the people are, but which data is considered personal. And so they're pretty similar definitions between China and Europe. I sort of bolded on the slide for you the ones that are really direct correlations. But essentially, any information that you've recorded, whether it's by electronic or some other means, that's related to an identified or identifiable person. So it is about people, actual individuals, not about corporations. So the whole corporate person thing doesn't apply here. So about actual people. And in China, they also specifically say this doesn't include information that's been anonymized. So if you're collecting data in China, it gets anonymized, and then you say export it to be handled or processed here in the United States. That wouldn't be covered because it's anonymized. The European definition, as you can see, is longer, but really what they're getting at is the same sort of keys. The main differences are that they give some examples in their definition of what's included. So, in the EU, they say, for example, an online identifier, would be included. Genetic material is included. So again, the identified or identifiable natural person is really a broad definition. So while it doesn't have those same examples that Europe has, essentially it's the same data and anything that could be linked back to an individual. So that's what we're dealing with here. And we also have within that a very special category of data that's called sensitive information that does have some additional rules and regulations around it that are different than just sort of general personal data. And we do see some differences in definitions here between China and the EU. So in China, when you're dealing with the PIPL, if the data that you are processing or handling is something that if it were leaked or improperly used, it could cause harm to the dignity of persons or to the security of their person or property, it's considered sensitive. And that's a very sort of broad definition, open to a lot of interpretation. And the EU doesn't have that sort of broad definition. They call this special category information, but they basically say if it's in this list that we're going to give you, it's special category, quote unquote, sensitive information. And they have a very specific list. China has this broad definition, and then they give a list that's a lot like Europe's list, but they say it could be other things too. So in China, for sure, if you are processing anything with biometric characteristics, so say a thumbprint, for example, religious belief information, specially designated status information, medical health information, any financial account information, that's a big difference from Europe. They don't have that on their list at all. Individual location tracking, or the personal information of a minor who's under 14 years of age. Those things are all considered sensitive in China for sure. There could be additional information that would also qualify though. And I'll give an example from the EU list, which is on the right-hand side of your screen. In the EU list, you'll see that they specifically mention sex life or sexual orientation data as being special category data. That is not on the list from China, but I think it's easy to understand how that type of information could cause harm if it were illegally accessed or if it were improperly used. And so, while the specific type of data isn't on the list, it could still arguably be considered sensitive data. So when we talk about the extra rules related to this information, it might be broader than just what's on the list in terms of what data it applies to. So we're talking today about information about people in China that's being processed inside or outside of China. If it's processed outside, if it's for the purpose of analyzing their activities, the activities of persons in China, or to offer them some sort of good or service. It's all qualified, and it's all going to require you to enter into ways to protect that information that we're going to talk about in a minute. But you also have to have a legal basis to process this information, and we'll get to that in a second. But the sensitive information on this slide will require special legal basis identification and protection. So just keep that in mind. But really quickly, so what actions count when we say when you handle the data? Essentially, it's any kind of processing. So if you're collecting the personal information, if you're storing it, if you're somehow using it, processing it, transmitting it, providing it to another party, so a disclosure, deleting it even is considered a processing activity. So all of these things are processing activities. They all qualify under both the European and the Chinese law as processing activities. So again, even though the European data here is longer, European definition is longer, and really because of the broad language used, it's the same. Anything that you do to European data right now that's covered by the GDPR, doing those same activities to data for people in China, also covered by the Chinese law. So just kind of keep that idea there. It's very parallel in that sense. So, okay, you're processing this kind of data, you're handling it in some way. What are the rules that apply? The first and most important rule is that you have to have a legal basis for the handling of the data, for the processing of that data. And so you have to look at any activity that you're performing on Chinese data and say, or Chinese personal data, and say, okay, do we have consent? Consent is a legal basis. If they've specifically said we can do this with their information. Is it for the performance of a contract? So we have a contract, we're fulfilling it, so we need, the shipping information, for example, to send the product. And those match in both jurisdictions. One thing you may be used to in Europe, if you're operating there, is the idea of legitimate interest, where if your business has a legitimate interest in processing the data and you establish it and it's reasonable and a few other things, you can process it. China doesn't provide that as a legal basis. So if you don't really fit into one of these categories of processing, there's not really a broad catch-all that will allow you to process the data anyway. So you really need to find a way to make one of these other ones fit. The vital interest of an individual. So this is mostly medical data that would qualify here. So, if a life-saving activity needs to be performed on somebody and you can't get their consent, maybe they're unconscious, maybe there's no time, whatever it is, you could go ahead and process the data. If it's required for meeting a legal requirement, so say there are tax laws in China that you're complying with, where you have to disclose information about sales that you've engaged in, or maybe you have employees in China and you have some legal requirements regarding the data that you report to the government, that kind of thing. You're allowed to engage in that processing activity. That's a legal basis for processing. And that again is the same as what you see in Europe. Another one that is not allowed in China that you do see in Europe is public interest of the government. So if you were, say, a government contractor processing data on behalf of the government, you'd be allowed to do that in Europe. China doesn't have that exact allowance, but the law is written really differently. And so essentially government processing activities are allowed, but they're not written into the law because they're sort of treated as not even being covered by the law, essentially. So it's not on the specific list of bases you can claim, but the government will still be able to engage in the processing that they want to do. And then a few that are allowed in China as legal bases for processing that are not allowed in Europe. One is for human resources management. In Europe, people are able to use the legitimate interest of the business or performance of a contract and consent to process that data anyway, but it's a specific legal basis in China. So if you have employees in China, you need to process their personal information for purposes of their employment, you can do that. A public health incident. So this is a little different than vital interests. And I think it's reflective of the fact that this law was written during the pandemic. And so if you need to process data, for example, contact data for contact tracing would qualify here as being in the public interest during a public health incident. And so that could potentially be a legal basis for processing. And then similarly, and again, this is a really big difference. I already mentioned that when we were talking about sensitive information, it could be to protect not just a person, the dignity of a person, but also to protect the security of their person, so their body or their property. And similarly here we see protection of property in an emergency as an allowed reason for processing personal data. So it's interesting to see that property addition there. That's pretty new, somewhat unique. So those are the legal bases required to process the data. And again, we mentioned sensitive data a few minutes ago. To process sensitive data, you're going to need to be doing it under consent. The majority of the time, you might have one of these, public health incidents or vital interest exceptions apply for medical information, but generally you'll need it to be based on consent, particularly if you're processing the information of minors. I know people are really interested in minors and online gaming in China right now because of another new law that they just passed restricting minors' screen time, where they can only play video games for 3 hours a week and it can only be on the weekend. So they're really interested in the personal data of their minors. So you need consent to process sensitive information, and for minors, you need it to be the consent of their parent or guardian if they're under the age of 14. So that's a special requirement that you have coming out of China right now. And so the majority of companies that are on the call today are, from Utah. And so if you're looking at compliance with this law, it's probably because you're engaging in cross-border handling of data, where you're taking the information out of China for some reason and bringing it somewhere else, most likely to the United States, most likely right here to Utah. If you're going to be doing that under the PIPL, just like with the GDPR, there's rules in place that are going to restrict when you can and cannot export data that's covered by the law. And so essentially you have to meet one of the following requirements. So, and I'll just tell you right now, most likely you can't do it right now. When I say right now, on November 1st, when the law goes into effect. So first, you could pass a security assessment by the Cyberspace Administration of China. That's the regulatory body charged with oversight of this law. Right now, they haven't publicized any sort of way to actually go through this assessment. So you can't really do it till we know how it would happen. Second way would be to undergo a personal information protection certification from a specialized body. And that specialized body would have to be authorized to certify you. And their authorization would come from that same regulatory agency, the Cyberspace Administration. We also don't have any specialized bodies yet that have been approved by the Cyberspace Administration. So if you're familiar with GDPR and you maybe previously participated in Privacy Shield, for example, this would be like that, where there would be an actual certification process. There'd be a body that could certify you, and that would mean you've checked the box and you can export the data. But we don't have an approved process yet. We don't have an approved way to get that certification. So again, pending. And then the last way, and the most common, if any of you are engaging in data transfers out of the EU right now, would be to enter into a contract between the exporting body and the importing body with standard contractual clauses that were approved by China's Cyberspace Administration. So this is the standard contractual clause, or SCC solution. This is, like I said, the most common way, where it's like, okay, we're just going to basically enter into a data processing agreement between the parties so we can export the data to the non-China party. Problematic because they haven't yet approved standard contractual clauses for China. So we can help companies, like sort of in the interim. We have a data processing agreement that, based on all of the regulations in the PIPL, it's like the closest you can come, maybe would be the way to describe it, to actually meeting all the requirements of the PIPL without us knowing what specific ones they might put into their standard contractual clauses later. But that's probably going to be the most likely way that companies are going to be exporting data from China. And again, it's the easiest. It's the one that's accessible to anybody. There's not really barriers to entry the way there are with passing a specialized security assessment authorized by the Cyberspace Administration. So that's the most likely. But again, we don't yet have those standard contractual clauses from China. We're still waiting on them. And then again, I mentioned there's just some really big generic phrases in the PIPL. There's one here too, where they just said, and also maybe in accordance with other laws or regulations of China. Very generic. Most likely what that's going to do is allow China to engage in processing outside of its own borders, where it might be engaging, contractors or others for the government, where they don't want to have to worry about some of these issues. But we don't really know what it means. That's just an interpretation that we've seen coming out of a few different sources. So again, like there may be an additional way, we just don't know what it would be yet if there's some new regulation that gets passed by the Cyberspace Administration later. And I think we can all understand that actually, in both California, when California passed their new law, and in Europe, there are gaps that the regulators are tasked with filling in. And this could be an example of that. So, if you're engaging in cross-border handling, we're still waiting for the standard contractual clauses. We can help fill the gap, but there's still going to be a gap until China fills it in with more regulation or authorization from their cyberspace authority. So how does this apply to you? Who are you in these transactions? Essentially, we just sort of wanted to lay out for you a difference in language that's really not creating any new differences in terms of how organizations are treated. So in China, if you're a controller, in Europe, it means you sort of own the data. You are the decision-making authority. It's the same in China, but they call you a personal information handler. And so the personal information handling entity determines the method and means of the data handling. So I, am the company that is selling a product in China, but I have maybe a local distributor who's going to actually fulfill the orders. I'm going to be the personal information handler because the distributor can only do things with the data that I tell them to do. I determine what they can and can't do and how they should do it. So I'm the handler. They are my entrusted person or processor. So they have to have a contract with the controller, the personal information handler, that tells them what they're allowed to do. That contract needs to limit how long they can handle the information for, and spell out some other rights and duties of both parties. and the entrusted person or the processor can't then transfer it on to yet another party without permission. And that is really in step with what we see in the GDPR. You know, you have your controller who makes the decisions, you have your processors who have to do everything on behalf of the controller, that are subject to a data processing agreement, and that cannot send it on to another third party without permission. So we really see that directly in step with the GDPR if you're operating in the EU. With that, what the kind of follow-up question is probably, okay, we know who we are, you know, we know there's some restrictions on the data, we have to have a legal basis to process it, we need some special restrictions in place before we can export it. What does it mean for people in China? And I think this is sort of the really exciting part of this law, because what it's done is it's given new individual rights to a huge proportion of the world's population. So under the law, people in China have the right to information or to notice about what data is being collected, how it's being used, who it's being shared with. And you'll see these are in lockstep with the GDPR all the way down. They have the right to access that information, which is sometimes called a right to know. They have the right to correct the information. So if the information being processed about them is incorrect, if it's incomplete, they can have it rectified. The right to have it deleted or erased. I think that's probably the biggest one that companies in the US have struggled with, because it's not quite as widely recognized as a human, privacy is not quite as widely recognized as a human right the way that it is in Europe. And I wouldn't go so far as to say it's been recognized as one in China under this law, but definitely some individual rights in the data have been recognized or created. They do have the right to data portability. That means to basically request that a company send their data to another company, potentially even a competitor. There's some limitations on that in China. The Cyberspace Administration can put some limitations on the protections. It's like, oh, if they're asking you to send it to another company that's not going to protect the data, essentially, you could say no in those situations because they still want it to be protected. They also, and this is an interesting one, they have the right not to be subjected to automated decision-making. And so essentially, if you're using, you know, like AI, if you're analyzing large data sets to make decisions about, you know, whether somebody's a good credit risk, whether, you know, you might hire or fire them based on some algorithm that's running as opposed to a manual or a human decision, they have the right to opt out of that. And so they also have the right within that to ask for more information. They can ask you to explain your processing. And it's not written that way in the GDPR. This is sort of a nuanced difference that I think we'll see more information coming out about later. But the idea that you might have to disclose how you're making a decision to a lot of companies is sort of a threatening thing, in the sense that that might be considered your intellectual property, your trade secrets, if those algorithms that you might be running are confidential in certain ways. So we have seen, you know, with some of the automated decision-making rules coming out of other jurisdictions, we've seen some pushback from private companies about what that really means. Individuals in China also now have the right to withdraw their consent. So maybe they consented to you processing their data at the beginning, and then they contact you and say, no, we've changed our mind, you can't process it anymore. You do have to stop if that was the legal basis you were using to process the data. And they can also lodge a complaint. So if you're violating their rights, if they think there's, you know, a security breach, any of these things, it's not quite the same in the sense of like they're not bringing direct suit against you the way that GDPR allows an individual to do, but they can lodge a complaint with the regulatory authority who then could come and take action, which Austin will be talking about. And then one thing that is different is next of kin have specifically been given rights in the GDPR, not the GDPR, in the PIPL in China, where, you know, with GDPR, your rights and your information essentially die with you. The definition of personal information in the EU is based around it being a living person. In China, if you pass away, your next of kin can exercise your data privacy rights. So I thought that was like an interesting little difference that may or may not impact your organization. as you're going forward. So these are sort of the broad contours of the law. And what Austin's going to do now is he's going to really describe how you comply with that from like a documentation perspective, and how, if you don't comply, what some of the enforcement outcomes might be for organizations that ignore the PIPL.
Great, thanks, Marie. So especially how our company approaches things of providing legal documentation, we wanted to go through, how to actually put this all into practice. So the next slide has a brief overview of the specific required documentation that you need under the PIPL. The 4 categories aren't complete news to anyone who's complied with the GDPR. You need to give notice to data subjects, the people who the information is about. You need to have contracts with entrusted parties or processors or vendors, as Marie discussed. And you need to have certain internal data handling policies set up. And in certain situations, you need to perform what are called impact assessments, which is, well, we'll go into detail, but kind of help you balance potentially dangerous uses of personal information and make sure that you have sufficient safeguards and that the purposes are appropriate for them. The 2 things to note, though, in addition to these categories are for the notice to data subjects in certain situations, which we'll go into, you also need to supply contact information to the data subjects of who you're sharing their personal information with. So under the GDPR or the CCPA in California, generally, there's a requirement that you list the categories of companies you share things with, like, oh, we use cloud providers to store information. Oh, we send your contact information sometimes to our business partners, things like that. But in certain situations, the PIPL requires you to specifically name the actual companies and give their contact info. So that could actually even be a separate document in addition to what's on your website, your privacy notice. You might want to have a separate document linked that says, here's all of the people we're sharing your information with who we're required to disclose. And then also the internal data handling policies are specifically references a security incident response plan. So if that's not already something you have, could be something you need to adopt. So let's go through each of these and what they actually require. The first category here, notice to data subjects, is essentially, for most companies, your website privacy policy. If you're collecting information through apps or other methodologies, you'll have to make this information available as well. But for simplicity's sake, let's call this your website privacy notice. As you can see, there's a lot of checks on both sides. If you're familiar with the GDPR, you're going to have to give people your contact information. If you have a data protection officer, then list them and how to contact them. You have to give the purposes of your processing and what types of information you're using, that kind of thing. As Marie mentioned, in the GDPR, if you're using a legitimate interest as the legal basis for processing personal data, in the GDPR, you have to disclose that. In China, the legitimate interest basis doesn't exist. And then possibly the most interesting thing here is this check plus. This is what I was referring to in that the GDPR, you have to give the categories of the recipients of personal information. And in general, you have to tell people, we also might transfer your data overseas to a country that might not have the same protections in law as the GDPR, but we're taking steps to make sure your rights are still protected. So specifically, if you're transferring data out of the GDPR to the US or another country like that, you generally have to tell people, we're doing this. Under the PIPL in China, if you're giving information to another personal information handler, which again is their jargon for a controller or another company that gets to decide what they do with it themselves, you have to name those companies and provide their contact information. And anytime you transfer data overseas to another organization, even if it's a vendor, then you have to provide information about how to contact those companies, which companies those are. One other difference is that the GDPR specifically requires you to inform data subjects about their right to lodge a complaint with the supervisory authority. Like, if you have a problem with how we're using data, you can go to, the government agency in your country that handles these things and complain to them. The PIPL in China also allows data subjects to make complaints to government regulatory bodies, but doesn't require you to specifically tell people about that process. And just briefly, if you're collecting images or using facial recognition technology in a public place in China, for whatever reason, there are requirements about having clear signage and for certain uses, even getting individual consent, but that is a bit more of a nuance. So next we have contracts with processors. As Maureen mentioned, the term in China for a processor or vendor is an entrusted party, which kind of sounds a little formal, but is, I think, somewhat descriptive. If you're entrusting your data with the other party and they're acting on your behalf, then that's an entrusted party, a processor. And just like the GDPR and the CCPA and most privacy regimes, you have to have a contract in place. This, you can see almost all the same stuff, so I'm not going to spend a lot of time on this. The confidentiality requirement in the GDPR, it has an X in China, but it's not required. It's not required in the sense that under the GDPR, you need specific language telling the processor, hey, you have to specifically require all your employees to enter into confidentiality agreements. In China, you don't need that specific language, but in practice, you're going to need to make sure that any processors and vendors are actually keeping your information confidential. The last thing to note here is that the GDPR has requirements around allowing the controller to audit processors. In the PIPL in China, it doesn't require that, but does say that the personal information handler, again, the controller, needs to supervise the entrusted party. And it's unclear whether that will include audits or be the same as audits or something kind of different, but something to keep in mind. Then there are also the internal policies that are required. In the GDPR, there are some sort of high-level things that you need to take into account, like privacy by design when you're creating products and having a default of relatively private settings for users. So if they don't go and change their settings, it's not giving away all their information to everyone type thing. China doesn't specifically mention that. It does have a principle of sincerity that companies have to follow. Not a lot of detail on that, but essentially it seems to be, just not deceptive or inappropriate ways. Both require things like employee training and internal audits. In the GDPR audits, internal audits are only required if you have a data protection officer. In China, they're always required if you're subject to the PIPL. There's data minimization requirements. Don't collect, more information than you need. Pseudonymization in both regimes can reduce the requirements. And in the GDPR, there are binding corporate rules for large companies that can be used specifically to transfer data to subsidiaries overseas. That is not available in China. And the last two things that are unique to China, I mentioned already, you have to have a security incident response plan. So basically a data breach policy. If we find out, we've been subject to a data breach, we've been hacked or something like that, or our vendor has, what are we going to do? Who we're going to contact? Do we have, legal counsel we can talk to? Do we know what the, government agencies we need to notify are? That type of thing. And in certain situations, China actually requires some companies to appoint independent oversight bodies and have kind of a number of other internal structures. That I think probably won't apply to many companies on this call. The specific language is any personal information handlers or controllers that provide important internet platform services that have a large number of users as determined by the Cyberspace Administration of China, although they haven't given that number yet, or that have a large, or whose business models are complex, need to appoint this independent oversight body and have a few other internal policy requirements. So we don't know, again, what the large number of users means. That should hopefully be coming out soon. But given the population of China and the huge tech companies that are there, I think it's safe to assume that it will be a pretty high number. The last set of required documents we're going to talk about are impact assessments. So in the GDPR, these are called data protection impact assessments. In China, they're called personal information protection impact assessments, which is a mouthful. And even trying to say that acronym PIPIA kind of doesn't roll off my tongue. So any influence I have around data protection law, I want to put into making sure we pronounce PIPIA as papaya. It goes much faster, much more memorable, and it's just better in every way, I think. But this is when you're doing certain types of data processing that can be riskier, then you need to do an internal assessment report that goes through and talks about what the processing is, decides, how necessary is this to our business? Is it proportional? Are we using the least information we need? What risks are there to the people whose information we're using, and how are we mitigating those risks? So that's required in the GDPR whenever you're doing automated processing or using sensitive personal data, and in other situations where you're doing systematic monitoring of public areas or large-scale processing. China doesn't have those last two situations where a PIPIA is necessary under the PIPL, but does say whenever you're disclosing personal information to another entity, you need to do a PIPIA. So even if it's just to a vendor, if you are sharing personal information with another company, you need to do one of these assessments. And anytime you transfer data internationally, you also need to do a PIPIA. That's not a requirement under the GDPR. And both have kind of a high risk catch-all if you're doing anything else with data that could be kind of risky or sensitive. So the other thing to note here briefly is that the GDPR has a number of factors you need to include in these DPIAs, how to balance all of this stuff. Regulatory bodies in the EU have given a lot of advice on this. In China, there's kind of a paragraph or two in the PIPL that kind of refers to most of the same types of requirements in these papayas, but it's unclear, what exactly they'll need. At this point, we're thinking that using pretty much the same process as the GDPR doing DPIAs is probably the best place to start. So we've created our tool for the PIPL based on the GDPR's impact assessment requirements. And then, sorry to bury the lead here, but the last things we're going to talk about are fines and enforcement powers. If you mess up, what happens? What's the bottom line here? So the numbers, fines can be up to 1 million yuan, which is, I think, as of yesterday or so, $154,000. That's for initial kind of uncorrected violations. And the big thing that's different in China under the PIPL is that it specifically allows for fining the individual in a company who's personally responsible for any violations. So it's not just that the company can be fined. In certain situations, individuals in the company can also be subject to fines, and that 100,000 yuan is about $15,000. Then for grave violations, there's a fine for up to 50 million yuan, which is about $7.7 million, or similar to the GDPR, there's a percentage of annual revenue threshold, it's up to 5% under the PIPL, whereas in the EU for serious violations, it's up to 4%. And again, for grave violations, the fines for individuals responsible can be up to $1 million yuan, again, 150 something thousand dollars. And for those grave violations, individuals who are responsible for those mistakes might be prevented from serving in high positions in your company or another for a certain period of time. And that leads into the general enforcement powers. Fines, of course, are one, but in general, there's similar powers to the GDPR, but also a bit more teeth in China under the PIPL. After ordering correction, they can also confiscate any unlawful income that you made due to the violation, and potentially compensation in the amount of loss to individuals or gains to your company. Like under the GDPR, they can order a suspension of service. You can't do business here, or you can't do this type of business, or you can't handle this type of information, things like that. And in certain situations, the PIPL notes that there can even be criminal liability. That is sort of a catch-all. It's not under the PIPL itself, but it says, if you violate the PIPL, that might also be a crime under other laws. So just kind of notes that. So there are a little bit more teeth potentially in China for some of these, and again, potentially even for individuals, not just companies that are in violation of the law. So as Kimball said at the beginning, this is a serious law. It's definitely something to look at and make sure if you're required to comply that you do. And the last thing I'd say is, we went through the documents that are required, and that's very important. As Kimball said, the first thing a regulator who has questions about your compliance with the PIPL or GDPR or CCPA is going to say is, show me all your policies, show me your documents internally, looking at how you handle data, balancing risks and things. And if you don't have those, then you're in usually pretty big trouble. But just having documents, of course, also isn't enough. The documents need to actually describe what your company is doing to make sure you're substantively complying with whatever law it is, whether PIPL, GDPR, or otherwise. So our company focuses the most on documents, but definitely something to keep in mind that the documents really reflect substantive procedures you need to have in your organization. Marie, do we have any other questions or final notes?
We have finished the questions that came in through the Q&A. So if you submitted a question there and you didn't see the answer, come back, take a look. They're all there now. I think probably the most interesting one, or maybe not the most interesting, but the most applicable one to most, I'll just sort of briefly, somebody was asking whether, if they don't have a presence in China, do they need to comply? And the answer to that is really sort of based on what you mean when you say presence. If you don't have a physical presence in China, you can still need to comply with the law. So, our parent company has a physical presence in China. They have employees there. They're processing data in China. They have to comply. But also, if as an organization, I'm maybe, advertising online and I'm getting customers in China and I'm offering them a service, even though I'm not present in China, I do still have to comply. And that's because, if you're handling the PI of those who are in China, the personal information of those who are in China, for one of the included reasons, which would either be to provide goods or services, or to analyze or assess the activities and behaviors of those people in China, then the law does apply to you. So, just think of it, physical presence is an easy way to determine it. You have an office, you have an employees, easy, it applies. But if you don't have those things, it could still apply to you, because a large number of organizations essentially reach out around the world now with their customer base, with their lead generation, their marketing activities. So you really do have to analyze whether you're doing those things, whether you're providing some sort of good or service inside of China, or somehow looking at the information of people inside of China and are analyzing it for any reason. So it really is pretty broad at the end of the day. And I will say, as a privacy leader in our company, I think Austin and I, one of the things we were joking about is like this is a law that could give us personal liability. It could really have a strange impact in a way that, the GDPR doesn't on individuals. I would definitely go after my parent company and say, well, you need to indemnify me. But, there's some nuances here that are really different that we haven't seen before. So I think that's important to keep in mind. And then I know we have Jim from the chamber here. So I don't know if you had any questions or any additional comments that you wanted to bring up, Jim, we'd give you some time before we close out.
Thanks, Marie. I don't have any additional comments. Thank you.
And I said the chamber, I meant the World Trade Organization.
That's right. That's right. I probably should make there's no confusion there. Big thanks to the Salt Lake Chamber, who's our partner. We certainly appreciate being confused with them because they're such an awesome organization. But we're really grateful for the time you've taken to educate our companies today. Clearly, this is really a critical timing to get this done. And SixFifty is going to be one of your best resources to do that kind of work. World Trade Center is here to support companies across Utah as they look to grow internationally. And SixFifty is just a critical partner, particularly when it comes to China and when it comes to these IP related, these data privacy related issues. So again, thank you, and hope to see you all again soon.
Thanks so much, Jim. Thanks, Austin. And thanks to the chamber as well. So if you are looking for the slides, they'll be coming in an email that the chamber will send out as a follow-up. So that was, I think, was our final question. So thanks, everybody.